Before we got hitched, married friends of ours sat us down and warned us about the perils of moving in with one another. They shared the challenges they had faced when they'd first moved in together, and it was only after they worked through the stressors of change that they felt confident enough to tie the knot. I give a similar chat to friends who are getting serious in relationships, but I've tailored it. I tell people that if they can build flat-pack furniture together without anyone crying, they're probably going to be just fine. And maybe that's the danger of rushed military marriages. Young enlisted service members must live in the fully furnished barracks. No living together, no flat-pack furniture. Disaster. And sometimes these marriages end the same way they began, quickly and with fireworks. When Sergeant Craig's marriage began to unravel, he was just 23 years old and struggling to move forward. He had a lot of options about how to handle his wife moving on, and he objectively made the absolute worst possible choice. This is Conduct and Becoming. I'm Erin, and I'm your host. Shaquille Craig joined the Army after a turbulent childhood, bouncing from family member to family member trying to find stability. His family considered him lucky to graduate high school and to get out of Selma, Alabama without joining a gang or developing a drug habit. Craig joined the Army just after high school, and the Army did its part to get him far away from the town he grew up in. Craig's first duty station was overseas in Korea, where he met and began a relationship with another soldier. She became pregnant, and they got married when they returned to the United States. Around that time, Craig purchased a personal firearm. He felt it was something he needed in order to protect his growing family. Sergeant Craig thought he had it all when he and his wife were co-located in Fort Stewart, Georgia. Nevertheless, they discovered they couldn't make it work. In October 2016, they separated and began the messy work of untying the knot. Craig's wife took primary physical custody of their 2-year-old daughter, which Craig says was very difficult for him. He describes his relationship with his daughter as very close, going so far as to claim they were inseparable while they lived together as a family. When the two adults separated, Craig asserts he requested to spend time with their daughter, and that he became upset when his estranged wife left their daughter with babysitters or family members when she went about her life and went out. I'm going to assume Craig and his estranged wife were approximately the same age, which means she would have been around 23 years old as well. By my sketchy math, that would put her at about 21 years old when she became a mother. I'm doing sketchy lawyer math because I think it helps ground us in understanding just how young everyone was when they got together and also when this marriage ended. And to confront how the Army Court of Criminal Appeals phrased some things. They described Craig's estranged wife as frequenting parties and clubs, which I took umbrage with because yes, duh, of course she's going to parties and clubs. She's 23 or younger and newly single. This is also why I couched his asserted closeness with their daughter in the way that I did. It's not really clear to me whether the issue was that Craig didn't get to spend time with their daughter, or that he was upset that his estranged wife was going out. There is, of course, no reason it can't be both. Craig claimed in an unsworn statement that he'd suffered abuse at the hands of his mother's boyfriends while he was younger, and that he wanted his estranged wife to, I don't know, remain celibate forever so his daughter wouldn't suffer the same fate. But moving on from a young, quick marriage means moving on. Craig's wife began to date while she figured out who she was aside from Craig's wife and mother to their child. But Craig still found himself enmeshed in her life. It seemed he was less prepared than she was to move on. When she moved to a new space for her fresh start in January 2017, Craig helped her move. Or he was there to snoop. Either way, he discovered a copy of her phone records. He confronted his estranged wife about a number she communicated with frequently. When she disclosed that it was a man she was talking with, both she and her date began receiving threatening text messages and phone calls from an unknown number. Her car was vandalized and several small personal items were stolen. Obviously, the best way to make sure that your ex doesn't introduce abusive men to your shared child is to become an abusive man, intervening, interrupting, and making threats. Craig's estranged wife reported the vandalism, theft, and threats to both the local police and Criminal Investigation Command, or CID, at Fort Stewart. CID's first stop was talking with Craig as the obvious, most likely candidate for big feelings about his estranged wife moving on. Whatever their investigation uncovered, Craig's command thought it was serious enough to cancel his orders to Korea. They issued a military protective order ordering Craig to abstain from contacting his wife. But the two weren't quite divorced, and there were still the issues of shared bills and splitting time with their daughter. So they used specialist Philip Thompson to act as a mediator. And I'm going to say it, Thompson sucked as a mediator. Craig urged Thompson to go to his estranged wife and report that Craig had attempted to die by suicide in order to garner her sympathy. Craig thought some sympathy was just the ticket to rekindling their love. Thompson agreed because he did in fact lie to Craig's estranged wife. Predictably, the story did not lead to a great love affair. On another occasion, Craig asked Thompson to let the air out of his wife's tires, which Thompson did. In the months that followed the military protective order, Craig still struggled to accept the breakup. Another soldier joked in a text thread about his wife's new love life, and that got Craig thinking. The lie about a suicide attempt hadn't worked, so perhaps he should confront the man she was dating. After all, his wife's new boyfriend, Private Malika Jackson, was also married. He and his wife had a 5-year-old, and she was 6 months pregnant. Saturday, March 4th, 2017 was a busy night for off-base parties near Fort Stewart. Craig and his buddies went to one party, while his estranged wife and Jackson went to another party in the same complex at Specialist Marquez Brown's apartment. Craig sent a friend to Brown's party to spy on his wife and report back what she was doing and who she was doing it with. Yuck. After everyone left the parties at around 2 a.m., Craig became the third car in a convoy to his wife's new apartment. She and Jackson drove their own cars, and Craig followed behind them. He waited for them to go inside before slinking out of his car and creeping around to peer in windows. Finally, he found one with a view and saw Jackson and his estranged wife cuddling on the couch. Knowing his estranged wife would recognize his car, he then swapped cars with a friend. He lied to his friend, saying he needed the unrecognizable car so that he could violate the protective order without anyone knowing, so he could sneak in and see their daughter. A side note, don't help your buddies violate restraining orders. Craig returned to his wife's new apartment and waited, staking out Jackson's car. When Jackson left, Craig followed behind him. Then, Jackson realized he was being followed, so he drove back to Brown's apartment, the apartment where he'd been at the party the night before. During that drive, Craig ignored all traffic laws and recommendations about phone usage while driving, and texted Jackson from that dummy number, asking, quote, "Did she let you smash?" Because slang has to be explained in appellate opinions, I will share with you that there is a footnote to this text that explains that smashing is a reference to sex. After Jackson arrived at Brown's apartment, both men tried calling and texting the dummy number, but Craig didn't respond. Craig decided this wasn't the right time to confront Jackson. Instead, he drove to a nearby library parking lot and called Thompson. Thompson declined the first call because he was sitting in church, but he picked up the second. Perhaps he assumed it was something urgent. Craig told Thompson to come meet him after he finished up church services that morning. Thompson dropped his wife at home, but his 4-month-old son had fallen asleep in the car seat and he elected to just let him sleep. When Thompson and his young son arrived at the library parking lot, Craig climbed into his truck, briefly exposing a handgun tucked into his waistband. He told Thompson his wife had brought someone else to the party the previous night and that she'd gone home with him. Thompson asked Craig if he'd taken pictures to use as leverage in the divorce, and Craig said he wasn't worried about photos. Craig placed a handgun on his lap and said Jackson had to go. Thompson asked Craig what he meant by that, and Craig repeated, "He's gotta go." Thompson knew then that what Craig meant was that he intended to kill his wife's boyfriend. Thompson claims he decided he had to keep Craig calm in order to keep himself and his infant son safe. So when Craig directed him out of the parking lot and toward Brown's apartment, Thompson went along with it, navigating back to the apartment complex. They parked and sat in the truck for about 10 minutes. Then Craig directed Thompson to go to the apartment and find out how many people were inside. Craig told Thompson to use the excuse that Thompson left his laptop at the party the night before. Thompson climbed down from his truck, leaving Craig and his infant son inside. He knocked on the door of the apartment and spoke with Jackson while Brown searched for the errant piece of equipment. Brown returned to the door to let Thompson know there wasn't a laptop inside, so he must have left it somewhere else. On his way back to the truck, Thompson claims that he tried to find some time to collect himself and figure out next steps by going to a nearby church. But he says that he found it locked up tight on a Sunday morning, so he returned to the truck to report what he found to Craig. There were only 2 people inside the apartment, Jackson and Brown. Craig set off alone. Craig entered the breezeway of the building and paused. I think we're supposed to assume he suffered a crisis of conscience and called Thompson. During that 7-minute conversation, Craig said he couldn't stop thinking about what happened the night before, that his wife had brought her new boyfriend to a party he didn't even go to, and that she brought him home to an apartment where he didn't even live. Thompson tried to reason with him, telling him to think of his daughter. Thompson says Craig didn't respond much during the call, and the two soon disconnected. With Craig clearly resolved to murder 2 people, Thompson peered at his phone for a moment. There was still time to call the police or to warn his friend and fellow soldier not to answer the door. There was still time to save Jackson and Brown. Thompson unlocked his screen and began searching online for a PlayStation 4 to purchase. A few minutes later, Craig called Thompson back and told him to leave, to go down the road and then come back. Thompson drove to that church parking lot and waited. Rehashing his feelings about his wife moving on seemed to steal his resolve. He was going to confront Jackson with 2 guns. Totally calm conversation. Craig knocked on the door to the apartment and says Jackson answered brandishing a kitchen knife. He said Jackson held it so that it was low but still visible. They moved their conversation inside into the living room of the apartment. Craig demanded to know whether Jackson had been with his wife the night before. Jackson said no. Craig reports that Jackson said he hadn't been, quote, with that bitch and that the derogatory word choice is what made Craig decide to kill. To me, that sounds like an excuse to garner sympathy, and we only have Craig to believe on whether Jackson actually used that word. We only have Craig to believe that this word is what made him decide on murder. I would argue that Craig made the decision to kill Jackson when he placed one gun into his waistband and another into his jacket pocket before staking out his wife's apartment for hours, following Jackson to a second location, texting him, telling Thompson that Jackson had to go, and sending Thompson to check how many people were in the apartment, how many witnesses might be there. But what do I know? Allegedly prompted by this terrible word, Craig drew the handgun from his jacket pocket and shot Jackson twice. The first bullet entered Jackson's face, penetrating his skull. The second hit him in the neck, killing him. Thompson, sitting in the parking lot of the church, heard the gunshot. This time, he picked up his phone and dialed. Don't get too excited, he wasn't calling 911. He was calling Craig, and Craig didn't answer. Brown emerged from his kitchen. This allegedly startled Craig, even though Thompson told him that Brown was there, and it was in fact Brown's apartment, not Jackson's. Craig fired again, hitting Brown in the face. Brown tried to leave through the back door of the apartment but couldn't get it open, so he retreated into his bedroom. Craig knew this was his opportunity to leave. He didn't really have anything against Brown. But Craig decided he had to kill him. He didn't want to leave any witnesses. Craig waited until Brown left the bedroom and shot him again, striking his right jugular vein and spinal cord. Craig pried the knife out of Jackson's dead hand and stabbed him twice in the neck, left the knife in Jackson's neck, collected his shell casings, locked the apartment door, and called Thompson to come back to the library parking lot. Craig returned to his borrowed car, and both Craig and Thompson drove to Thompson's house, where they began to cover up the murders. First, Craig gave Thompson the waistband gun, the gun that was not used to kill two people, to hide in his home. While there, Thompson dropped off his son, his truck, and the firearm. Then, Craig drove Thompson in the borrowed car back to the car's owner and changed clothes. Craig disclosed to his friends that he'd just murdered two people and demanded they keep it just between them. Thompson asked Craig to drive him home, but instead they departed for the woods. Craig hid the gun he did use to murder two people and asked Thompson to return in a few days to burn the bloody clothes. Then, Craig finally dropped Thompson back at his own house. After a final reminder to Thompson to not tell anyone about the murders, Craig left. In the evening on that Sunday, the Hinesville Police Department received an anonymous tip. They traveled to Brown's apartment at around 8 p.m. and discovered the two slain soldiers. It could have been one of Craig's friends that made the anonymous tip, but it could have just as easily been any one of the neighbors that heard 4 gunshots that day. When local police identified Craig as a suspect, they looped in CID. When questioned, Thompson revealed that he'd aided and abetted Craig. He'd driven to the parking lot to meet Craig, gone to the apartment to scope it out, and waited for Craig after the murder. He knew he'd helped his friend commit murder, but he also hadn't actually wanted Jackson and Brown dead. He told investigators he'd hoped that no one would get hurt. 4 days after the bodies were discovered, civilian police arrested Craig. They kept Craig in the civilian jail for a total of 263 days, though Army prosecutors preferred charges against him 5 months after his arrest. For his part, Thompson was charged with conspiracy to commit premeditated murder and 2 specifications of premeditated murder under a theory of aiding and abetting. He pled guilty to the 2 specifications of premeditated murders and was sentenced to a dishonorable discharge and confinement for 35 years. Over in the civilian jail, Craig was part of the general population of pre-trial inmates. When he transferred to the Naval Consolidated Brig in Charleston, South Carolina, he was placed in maximum custody status based on the seriousness of his alleged offenses, double premeditated murder, and the severity of his potential sentence. He faced a potential death sentence. In the maximum security area of the brig, Craig spent 22 hours alone each day. He was not allowed to work or attend religious services. He could only watch television through a slot in his door. Craig was allowed to spend 2 hours outside of his cell each day for showering, spending time alone in the recreation area, or talking to other maximum custody inmates through a fence. I cannot pretend that these conditions would be easy for anyone to endure, and I do think this is something that really affected Craig's mental health. Craig was someone who so very clearly could not handle being alone. He couldn't handle his wife leaving him. He couldn't even handle the walk from his buddy's car to the scene of the murder without pausing to make a 7-minute phone call. Predictably, Craig did not enjoy his time in the maximum security area of the brig and periodically requested to downgrade his custody status. Every week for the first 2 months of confinement at the brig, officials reviewed his confinement status, and every week the prisoner management director, clinical department, medical department, chaplain, and civilian administrators decided to maintain his custody status. After the first 2 months, they reviewed his status monthly. One of the guards who supervised Craig even advocated to downgrade Craig to a lower custody status. But because of the nature of Craig's charges and the severity of his potential punishment, the brig board couldn't change his custody status. They couldn't move him to a less secure area of the prison, but they could allow him greater privileges. He graduated to 6 hours outside his cell each day. He could watch TV in a common room and socialize with other maximum security inmates. He had access to books, board games, a treadmill, and stationery if he wanted to write letters. In January 2019, around a year and a half after the murders, Craig transferred to the Army's Joint Regional Correctional Facility at Fort Leavenworth, Kansas. At Fort Leavenworth, they had a greater range of options, and corrections leadership downgraded Craig's custody status, which gave Craig greater social time with other people awaiting trial. Finally, in February 2020, Craig's trial began. Craig and his detailed military defense counsel repeatedly moved to appoint a retired Army judge advocate with experience in capital cases as an expert consultant for their team. The detailed military defense counsel had no experience with homicide cases, let alone capital cases. Both the convening authority and judge denied their requests. Eventually, Craig elected to make a plea agreement. He requested a maximum sentence of life with the possibility of parole. The convening authority denied that request, offering instead to take the death penalty off the table, leaving it up to the sentencing judge to select whether or not Craig would be eligible for parole while serving his life sentence. In accordance with that plea agreement, Craig pled guilty to 2 specifications of premeditated murder, 2 specifications of obstructing justice, and 1 specification of violating a lawful order. The judge considered testimony from the families of the 2 murdered soldiers about how much they were missed and what sort of people were stolen away by 2 brutal acts of violence. The judge also considered video testimony from 13 people about the kind of person Craig is and was. They described him as good-natured, funny, and willing to help others. He offered 37 character letters from his extended family, middle and high school friends, and soldiers he'd worked with. 12 more people testified live in court. They called him a good influence, a mentor, and a voice of reason. They spoke of the void his incarceration would leave in their lives. But Craig's confinement wasn't the only void that his decisions created. Jackson's family spoke of the void they faced. His wife was 6 months pregnant when he was murdered, and she shared the challenges she faced as a single mother trying to raise 2 children. She spoke of their 5-year-old son who, in the days following his father's murder, waited by the front door asking when he would return. Jackson's mother spoke of the repeated phone calls she made to his number after his death, just to hear her son's voice one more time. Mitigation witnesses explained that Craig grew up in a difficult neighborhood and that his parents hadn't been able to provide the stability he needed, so he went to live with his paternal grandmother. He was, they thought, so lucky to avoid drugs and gangs. It's worth noting that Brown escaped a similarly rough neighborhood when he followed in his grandmother's footsteps and joined the army. His single mother raised him to be a light in the lives of others, including the siblings he helped care for. Craig himself tried to explain to the judge that he'd gone to the apartment that day to confront Jackson because he felt betrayed and sad and, quote, disrespected. He also said he really wanted to know what was going on. But I don't think those things can be true at the same time. I think Craig did in fact know what was going on, having staked out his wife's apartment all night. I think Craig had to know what was going on in order to feel betrayed and sad and disrespected. Craig explained to the families of the men he killed that he was sorry, that he took full ownership of his actions, and that he cannot forgive himself for the damage he caused. Maybe the judge had the same reservations that I have, and sentenced Craig to confinement for life without the possibility of parole, a reduction to E1, and a dishonorable discharge. On appeal, Craig asserted that the conditions he lived in before he got upgraded privileges at the U.S. Naval Consolidated Brig in Charleston were tantamount to solitary confinement. This, he claimed, was illegal pretrial punishment in violation of Article 13 of the Uniform Code of Military Justice. The Army Court of Criminal Appeals, the ACCA, gavel-gavelled and said that the confinement conditions, while restrictive, didn't violate his Article 13 rights. They reasoned that the confinement conditions at the brig weren't intended as a punishment, and they were the same conditions everyone in the same classification faced. These were in fact the only conditions that this particular medium-security brig could house Craig under. The more interesting appellate argument to me was that Craig believed that the sentence of life without parole for 2 premeditated murders, 2 specifications of obstructing justice, and 1 specification of violating a lawful order was inappropriately severe. I think we can all agree, legal beagles, that what it came down to was whether life without parole was inappropriately severe for a double murder plea deal. The other specifications are just kind of there also. The big bad here was murder. Craig argued that a sentence without the possibility of parole was inappropriately severe, first, because the government's conduct was fundamentally unfair, second, because of documented racial bias in the criminal justice system, and third, because he submitted a high volume of mitigation evidence. The ACCA considered the entirety of the record of trial when they contemplated the fairness of the government, including the multiple denials of the defense capital case expert. Then they seized upon the supposed win in the plea deal negotiation. In Episode 5, the Hennis case, I talked about how infrequent military executions are in the United States, and I questioned whether Hennis's death is a true, realistic outcome. Here, the ACCA asked the same questions. They wondered what sort of victory it was to get the death penalty off the table when the last military execution was over 60 years ago. Is a death sentence at Leavenworth all that different than a sentence of life without parole? Finally, the ACCA turned to the mitigating evidence. The mitigating evidence that called Craig level-headed and a voice of reason, highly regarded by his peers and superiors. They reasoned that this volume of mitigation was significant. They found the forensic psychologist's testimony about Craig's future risk compelling. That psychologist testified that Craig wasn't likely to reoffend because he was young, lacked mental health issues, took responsibility for his crimes after policing his brass and hiding all the evidence, wasn't in a gang, had 2 years of college education, and didn't have a previous criminal history. I don't know how persuasive the lack of a previous criminal record is for me when someone's current criminal record involves a double homicide of fellow soldiers, but that's apparently beside the point. The ACCA believed, based on the written record before them, that Craig was genuinely remorseful, ashamed, and guilty in his unsworn statement. Taking all of this into account, they affirmed the dishonorable discharge and reduction to E1 without modification, and affirmed only confinement for life with the possibility of parole. Remember Thompson, Craig's friend, who let the air out of his wife's tires, reported the false suicide attempt, and served as a murder Uber while his 4-month-old slept in the back seat? Thompson also appealed his sentence of 35 years confinement as inappropriately severe. And because he said in his colloquy with the judge during his Providence inquiry that he didn't actually want Craig's murderous plot to succeed and didn't bear any ill will towards the victims, he didn't actually have the requisite mental state for aiding and abetting premeditated murder. Though he'd gone through the actions of aiding and abetting, the actus reus, he didn't have the required mental state, the mens rea. Concluding that the military judge erred by accepting Thompson's guilty plea, given his mental state, the ACCA set aside his guilty plea and sentence, and authorized a rehearing. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time, but be sure to bundle up. We're taking a trip up to chilly Alaska. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense.